Hi there, this is Jay Rodarmal with LifePlan Lawyer. I'm a wills, trust, and probate attorney here in California. So there is a clause that we'll see in a lot of wills and trusts, and it's a clause that says that any person who does not survive me by more than X number of days will not inherit. And in the trust side draft, it's typically 30 days. Sometimes it's, just 3 days, or sometimes it's 120 days, so it can vary. But what's that all about? Why in the world would we do a clause like that? And I used to think, well, hypothetically, if two people were in the same car accident, or two people died from the same sickness or disease, then we don't want one person to die and then the second person dies 3 days later, and now we have to do two different administrations. So, a second trust administration, or in some cases that second person doesn't have an estate plan. If it's a child of yours, maybe they don't have their own plan, and so now parent can die leaving it to child, and because the child doesn't have a plan, now you're into probate court for the child. So that is an example of why you would want to have this survivorship clause, just to kind of keep things simple. I have a couple of interesting situations that have occurred just in the last couple of years here, where not having that clause has been a real issue. So I had a gentleman that I was helping with a probate situation. So this is someone who didn't have a plan together. Actually, they did have a will, but they didn't have a trust. And in their will, he decided that I am going to leave my assets to my brother and to one of my two sisters. So I will call the sisters the good sister and the bad sister, not because she was bad, but certainly this brother thought she was, because he decided to disinherit her. So brother says, when I die, 50% to my brother, 50% to my good sister. I am disinheriting my bad sister. Well, he passed away, and as things would happen, the next day in an entirely different state, his sister died. So I went scouring his will to see, does it have any language in there about survivorship, and it didn't. So I thought, well, let me look at what California law says. And California law says that there is I believe it's 120-hour survivorship requirement. However, that 120 hours does not apply if you create your own will. So the idea is, if you're smart enough to create your own will, then you must know what you want to do. And so there must have been some reason why you wouldn't have put this 120 hours in there. So end result, unfortunately, is that the gentleman who died, half of his estate went to his brother as planned. The other half that was going to go to his sister instead went to her estate. And it turns out that her estate went back to him. Of course, he wasn't alive at the time she died. So that failed, and the rest of it went to the disinherited sister. So end result is half of his money went to the sister that he really didn't want to inherit. So these clauses that you see in trusts, you wonder, well, will that ever happen? Yes, they can happen. And so on that note, not to leave you on a sour note, I'll point out one other scenario that happened in the last year. And this was a more positive outcome. This was a mother who had a trust, and her son also had a trust. And they were both, older adults, neither very young. And both the mother and the son passed away within short time period of each other. So it was actually the night before that the mother died, and then the next day the son died. And so again, looking in the mother's trust, what happens if a child dies after her? In this case, it was a fortunate result that there was no survivorship requirement because it meant that mom's share did go to her son, and as it turned out, her son had made provision for his wife, who the family all gets along with, and so therefore the son's wishes were honored, and his share of the estate went to his wife, rather than skipping her and going instead to the rest of his siblings. So it doesn't always work out against you, but certainly you want to be the one deciding what's going to happen if one of my relatives or beneficiaries passes away shortly after I do. Thank you.